It's important to examine the history of law in order to frame a study of criminal law. While television shows and movies are often focused on criminal law, exciting courtroom trials, and whodunits, this doesn't accurately represent the majority of law in the United States. Author Lawrence M. Friedman, in his book A History of American Law, states, "Law is a mirror of society." He goes on to note, perhaps it is a distorted mirror. In other words, the law, not just criminal law, reflects the unwritten rules, norms, attitudes, and beliefs of a society. It could even be considered the written manifestation of our social contract, the way we agree to live our lives with each other. We often think of criminal law as the main focus of our laws. In reality, criminal law is only a small portion of the whole body of law practiced in America, both historically and in the present, and is dwarfed in comparison to areas such as real estate, contract, and probate law. In fact, the overall history of law is primarily focused on commerce, business, and economics. For lack of a better word, money. Historically, certain parts of American law can be traced very far back, such as juries, mortgages and trusts, and some aspects of land law. What Friedman calls the living law, that is, the law we use every day, such as tax law, social welfare laws, and traffic codes, are all fairly new. The fundamental building block of sorts of American criminal and procedural law is English common law. This is something you've probably heard before. Common law in England was law belonging to the royal central courts and the wealthy landholders. Common law hardly concerned the peasants. In England, land equaled power. Common law was brought to the United States when the colonies were established on the East Coast, where it immediately began to be modified to adapt to the conditions in the colonies. The law of early America was very different than the law of England. In America, there were few books and even fewer law books, not to mention a low literacy rate. Most importantly, however, unlike England where few people had land, in America there was a lot of land and a lot of people had it. Since the overall field of law had been reserved for wealthy landowners in England, law in America became important to everyone, particularly when it came to business, commerce, and money. Common law, as it had been brought from England, was focused on both offenses and procedures. This remained the same, but early on in the colonies, attempts to codify or write down offenses and procedures began to be made. According to Friedman, the reason behind this may lay in democracy and a simple penal philosophy that no one should be punished for crimes not clearly and openly labeled. Some of this philosophy was probably grounded in punishment. Shame, humiliation, and repentance for offenses was prevalent since punishments were often public and communities were small and gossipy. The mark of being convicted could almost be overwhelming. Therefore, it had to be fair. Today, our American legal system, including criminal law, is primarily based on codified or statutes and judge-made law. So what is enacted by the legislature or Congress is considered law, as well as what a judge rules. It becomes law as well.